Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now take a look at this. Ripple, XRP, and SEC have filed their briefs, judge to pass verdict. Lawyer says, both the Securities and Exchange Commission (YES) and Ripple have submitted their respective arguments in the ongoing case about XRP. According to Jeremy Hogan, the judge is anticipated to announce the verdict. There is no doubt in Hogan's mind that XRP will not be classified as a security. Both the United States Securities and Exchange Commission (SEC) and the American fintech company Ripple have submitted their respective briefs in the ongoing case that the SEC has filed against the blockchain payments company. An influential attorney and partner at the law firm, Jeremy Hogan, wrote in a post on the social networking platform X, which was formerly known as Twitter, that the Ripple versus SEC briefs are finished. He went on to say, I think the SEC went out with a whimper here. It did not even attempt to challenge ODL sales. Rather, it just pointed out that Ripple was attempting to relitigate the issue, which is exactly what it is. And there was no fresh information regarding the damages. In contrast, Hogan asserted with self-assurance in a post that he made on May 3rd, X, that he is positive that Ripple will not be deemed a crypto asset security unregistered this summer. This declaration was a direct response to Michael Saylor, the former CEO of MicroStrategy, who suggested that cryptocurrencies such as Ethereum, BNB, Solana, Ripple, and Cardano will be classified as securities in the coming year. A final remedies brief has been submitted by the United States Securities and Exchange Commission in response to the brief that was provided by Ripple Labs. All the filing's attention is directed toward the requirement of disgorgement and permanent injunctions. As a result of the SEC's attack on Ripple, the chief legal officer of the company, Stuart Alderati, has taken this opportunity to criticize X and call into question the SEC's dedication to the equitable application of the law. During this final court filing, the Securities and Exchange Commission presents its argument for more severe fines, while Ripple contends that the SEC's demands are excessive. An argument for injunctions made by the SEC is there is a reasonable likelihood that Ripple will continue to commit the same error. The Securities and Exchange Commission contends in its final brief that there is a need for permanent injunctions to prevent this from happening. Even though the litigation has been going on for 3 years, the Securities and Exchange Commission continues to assert that Ripple's core business continues to be as it has been since 2013, unregistered sales of XRP. In light of this, the Securities and Exchange Commission contends that even if Ripple had not committed a single violation since the year 2020, it would still be possible for another violation to be anticipated. In the previous brief that Ripple submitted, which was connected to remedies, the company stated that it had made the required adjustments to its business model to prevent future violations. This assertion, however, is met with a rebuttal from the Securities and Exchange Commission SEC, which asserts that Ripple's first assurance is not even an actual assurance. It is instead another attempt to reiterate summary judgment argument. In its most recent summary of remedies, the Securities and Exchange Commission appears to be pointing the finger at the firm, claiming that any adjustments made by Ripple are nothing more than misreading or ignoring what the order says, a permanent injunction prohibiting Ripple Inc. from continuing its business is the basis for the argument that the Securities and Exchange Commission SEC brings forward. A furious chief legal officer criticizes the approach taken by the SEC following the release of the SEC's remedies-related brief to the public. Criticisms began to pour in. Ripple's chief legal officer, Stuart Alderati, responded angrily to the SEC's final remedies brief. Alderati made the following observation on X, more of the same from the SEC failing to apply the law faithfully and trying to pull the wool over the judge's eyes. Additionally, Alderati voiced his disapproval of what he saw to be a lack of respect on the part of the United States Securities and Exchange Commission for international regulatory systems. And just when you think the SEC can't sink any lower, know that the SEC has no respect for you and thinks you are handing out the equivalent of fishing licenses, he wrote. If you are a financial regulator outside of the United States and have done the hard work of establishing comprehensive crypto licensing frameworks, you should know that the SEC has given you the equivalent of fishing licenses. The financial stakes and the decision that is coming soon, the Securities and Exchange Commission, made it quite plain in its last brief that it will not be rescinding its demand for penalties and fines totaling $2 billion. The Securities and Exchange Commission cited the millions of dollars in earnings that Ripple claimed to have made from its unregistered sales of XRP as the basis for the disgorgement of this insane amount. Ripple's arguments against disgorgement are deemed to be without merit by the Securities and Exchange Commission, which states that the SEC has shown that Ripple's violation is failure to provide statutorily mandated disclosures about pricing and discounts caused pecuniary harm because some institutional investors paid more than they would have had. They received all required information. On the other hand, Ripple's most recent brief suggested a penalty amount that was substantially lower than the one that was offered, indicating that a punishment of less than $10 million would be more suitable. Specifically, it asserted that the expectations made by the SEC were just too severe. Despite this, Mr. Alderoty, the chief legal officer of Ripple, has expressed optimism over the progress that Ripple has made in resolving the litigation. What is left is for Judge Sarah Netburn to evaluate the briefs and issue the final court finding, which will determine whether the SEC's injunctions and disgorgement claims are upheld or whether a settlement is reached as a precedent for future enforcement proceedings in the cryptocurrency business. At this moment, Ripple is waiting for a crucial verdict that has the potential to rethink its on-demand liquidity operations. Ripple could be subject to stringent injunctions as a result of the SEC's remedies, which would have an impact on institutional sales. An explanation of the legal standing of XRP's post-complaint sales will be provided by the decision of the court. An important turning point is drawing near in the ongoing legal dispute between Ripple Labs, Inc. and the Securities and Exchange Commission of the United States. A redacted version of the final remedies reply brief that the SEC has prepared will soon be made accessible to the public. This brief is essential to the judge's upcoming judgment. This new development may have a substantial impact on Ripple's operations as well as the entirety of the cryptocurrency industry. It is anticipated that the future verdict will primarily address the request made by the SEC to freeze particular Ripple transactions. Sales that are associated with institutional and on-demand liquidity, OWED, services are included in this category. Ripple's operations on the open decentralized ledger AdLed could be validated by the court's ruling, which will be of critical importance. Moreover, the court will render a decision about penalties or disgorgement for suspected violations of securities laws with a particular emphasis on transactions that occurred after the initial complaint was filed by the SEC. The conclusion of this case may establish a precedent for the regulation of digital assets in the United States. The community of cryptocurrency investors and enthusiasts is keeping a close eye on this particular situation. The outcome of this could have a significant impact on the development and use of blockchain technology. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page before making any decision about investments. We strongly advise conducting independent research and consulting with a knowledgeable professional.